Okay, it is Monday, September 29th. This is being recorded with Section 2, and we're going to talk about the Module 7 materials, which is the second half of marine insurance. Previously, we got an introduction to the 3 or 4 types of marine insurance, if you want to include pollution insurance, and a fairly detailed discussion of P&I. Nothing really of any substance on hull, because we're just noting that it exists and not getting into the nuances like the running down clause. If you're interested, it's in the text. We also talked quite a bit about cargo insurance and a little bit about pollution. A little bit about pollution insurance. Just the idea that it's really reinsurance, and whether you want to conceptually frame it as a separate type or as an extension of P&I, really, because it covers liability, you can. But of course, P&I is its own unique thing, because it has all of these rules and properties that are different from ordinary commercial underwriting. Quick recap, in P&I, it's not an insurance company per se, it's a club that is basically a big pool of money into which the members put money to cover for losses. And instead of paying premiums, they're subject to calls. And those calls are not finalized all at once. You can be subject to back calls. So if the club pays out a lot in 2025, the member may pay some back calls in 2026, because they do their bookkeeping, and it turns out that to make ends meet, they have to get more money from each of the members. So it's a mutual assurance association, quite different from underwriting. Another oddity in P&I is the pay-to-be-paid rule, which we discussed. I'm not going to revisit it now. But actually, I will revisit it when we get to the subject of letters of undertaking. We did not record any video that discussed letters of undertaking. With this section, in an unrecorded talk that I gave a little too early, I did introduce the concept. Does anybody remember what a letter of undertaking is? Sometimes abbreviated LOU. So a letter of undertaking is kind of like a bond. And the idea is that the P&I Club will issue one. And it's usually just a letter from a law firm. And you don't have to do the formal bond thing like with bail bonds. Anybody ever need a bail bondsman? That's a trick question. Sort of like, have you ever been arrested? Anyway, the bottom line is that letters of undertaking really do 3 things. There's a lot of 3s in admiralty law. And they are issued when a vessel gets arrested. Because when a vessel gets arrested, and we haven't covered vessel arrest yet, but what happens? The vessel is stuck there in port. The U.S. Marshals come aboard, and they put a notice on the vessel, and there's a custodian. It could be the Marshals, it could be a substitute custodian. And the vessel is now in the court's jurisdiction, and there's a claimant or a group of claimants against it who have maritime liens against the vessel, and they're suing the vessel in rem. And when we get to in rem jurisdiction and maritime liens and ship mortgages, we'll delve into that more. But we already know from previous talks that the vessel itself can be a defendant. And when that happens, it's a big mess for the ship owner, right? Because a vessel sitting at a dock, unable to move its cargo, paying crew, paying all kinds of operating expenses, and not going anywhere, is like a bleeding loss. It's not making any money. So, the idea of a letter of undertaking evolved. A lot of things that happen are just good business sense to solve problems, and it makes everybody happy. So I'll get to the part that makes the ship owner happiest last. So what does a letter of undertaking do? 3 things. 1, and I'm going to ask you a thought question about 1. The P&I Club, I'll just say club, agrees to pay all proven, I'm going to underline proven, claims. Why do I underline proven? Well, if somebody says, you hit my bridge and it costs $5 million, P&I Club isn't just going to fork over $5 million as soon as the arrest occurs. It's going to get litigated. The club or the management arm of the club will assign counsel to go to litigation, and proven or settled, I guess I should put an asterisk, because you could settle the claim too. or settled. But the bottom line is the claims aren't ripe just when the ship gets arrested. So the P&I Club is agreeing to pay all proven claims, which makes the claimants happy because now they have a deep pocket and they know that if they succeed in court or get to a settlement, they'll get their money. Now think about this. The P&I Club issues this letter of undertaking and agrees to pay all proven claims. What happens to the pay-to-be-paid rule? Does the member have to pay the claims first and be reimbursed by the P&I Club? If that were the case, nobody would want a letter of undertaking because if the vessel owner is not solvent, the P&I Club is pledged to pay all proven claims, but gee, the ship owner doesn't have any money, so P&I Club's off the hook. No claimants are going to agree to that. So the letter of undertaking is a built-in way around the pay-to-be-paid rule. If the P&I Club issues a letter of undertaking, it has to pay those claims, whether the member has the money to pay them first to get reimbursed or not. So that's conceptually an exception to the pay-to-be-paid rule, which we talked about before. What is the second thing that the letter of undertaking does? Well, to maintain jurisdiction over a vessel, in rem, the vessel has to be in the district under the court's control. The U.S. Marshals have the vessel. There's in rem jurisdiction over the vessel because it's sitting right there on the dock in Brooklyn, and the Eastern District of New York has maritime in rem jurisdiction over that vessel. But I actually have to get to number three. Number three is vessel may sail. So part of the letter of undertaking arrangement, LOU, I'll just say vessel can leave. Okay? So that's the part that makes the ship owners happy because now the vessel can continue to trade. You're paying for crew that's actually doing something. You're paying overhead costs for something that's actually making money. You're fulfilling your contracts too, because if you have cargo on board and you can't deliver it, your customers, the cargo interest is not going to be very happy. So that's the third part. And remember I just said that the court has jurisdiction of the vessel only if the vessel is in the court's geographical jurisdiction under arrest. This is an exception to that. What does the P&I Club, what does the P&I Club agree in the letter of undertaking? Number two, that the court can retain jurisdiction over the vessel. You can agree that the court can have jurisdiction over the vessel even if the vessel is no longer in the marshal's custody. So that's an essential part because if the claimants want to go to court and prove their claims, the court has to have jurisdiction over the vessel. It's an in rem claim against the vessel, maybe with in personam claims against the owner, carrier. But the bottom line is that the court maintains jurisdiction under the letter of undertaking, otherwise it would be worthless. We'll pay all proven claims, but if you let the vessel sail, you can't litigate in court anymore and you can't prove your claims. Ha ha ha. That wouldn't work. So court retains jurisdiction, and I'm a little short of space, so I won't say in rem, but that's the vessel itself is the defendant in rem, and I guess I don't know if it'll show up on the screen on the camera, but it's in rem, where the vessel itself is the party. So three things that the letter of undertaking does. One, the club is agreeing to pay all proven claims, or if they're settled, they'll pay them too. But the bottom line is that now the claimants don't have to worry about if they win their case, they might not get paid because they have a deep pocket there. The P&I Club is pledging to pay them. Two, they don't have to worry that the vessel has to be kept in the jurisdiction in order to have the proceeding go on in federal court. The proceeding can continue even now that the vessel has left. And three, obviously, the vessel can leave. And that's from the ship owner's perspective, three is crucial. And of course, if they have a P&I Club, this is one of those protection parts. It includes indemnity because they're agreeing to pay the claims, but the service of providing a letter of undertaking is part of the job of protecting members that the P&I Club provides. The letter of undertaking is a really important device. Otherwise, you'd have, ports, I mean, it'd be bad for everybody. Ports would be clogged with vessels that are stuck under arrest, not going anywhere, piers would be tied up, it'd be a big mess. So it's a very important device in maritime commerce that obviously ties into maritime law and obviously ties into marine insurance. So they all kind of interconnect. And you really shouldn't graduate from this place without knowing about letters of undertaking. I mean, if you're going to be in the business, you do want to have an idea of how this device solves problems for everybody. The claimants are happier, the ports are happier, the vessel owners are happier, and it's really much more efficient, from an even more global perspective. I mean, there's something wrong with vessels that are, sitting around and doing nothing, to some extent still, causing some environmental cost, right? I mean, they might still, I don't know if they burn fuel because they're not on the way, but they're obviously using electricity and maintaining space, and might be some discharge into the waterway, maybe legal, maybe not legal, who knows? But the bottom line is everybody's happy with this arrangement. It's better for everyone. I can't think of a single entity or party or person who would not be happy with this arrangement. The cargo interests are happier because their cargo gets to be moved, right? If the cargo was tied up, the ship is tied up at the dock under arrest for 6 months, and the cargo is sitting there, the cargo interests have to make other arrangements. They have to have the cargo removed by crane, et cetera, et cetera. Important thing here, the lien on the vessel is not necessarily a lien on the cargo. So if that were to happen, the cargo interest could get their cargo off. But the easier way is to have a letter of undertaking and allow the vessel to sail, so the cargo interests don't have to worry about that. Everybody clear on that so far? So the letter of undertaking is got to be the single most important and somewhat complex thing that P&I clubs do. Complex because it relates to the whole big picture of what's going on. The cargo has to move, there are cargo interests, there's the jurisdiction of the court, and all that kind of comes together in the letter of undertaking. So to understand the letter of undertaking, you have to be familiar with the idea that vessels themselves can be defenders in rem. You have to understand how P&I clubs work. You have to understand how cargo works in general, that it goes on the ship and has to be delivered from point A to point B. And as I said, it's not a bond where somebody has to put up money with buy a bond and pay $10,000 for $1 million bond or whatever the numbers are. You don't actually pay anything. Nobody pays anything. The member doesn't even pay extra for the service, as far as I know. I mean, it's all provided with their P&I coverage. So it's a really important part of the P. The protection, because the member's interests are protected, the member being the ship owner, the carrier interest, and they get to keep doing business after their vessel's been arrested. And we're going to get into more of the details about vessel arrest and maritime liens and stuff when we get to that section of the course. And there's a whole somewhat complex priority if the vessel doesn't sail and the vessel has to be sold at auction, which is what eventually happens if there is no P&I club. Who gets first dibs, on the money when the vessel is sold? Because often, if there's no P&I club and no letter of undertaking, and the vessel sits there and the claims proceed in court, and then what happens is the court will actually sell the vessel at auction, and very often the money that's raised is not enough to cover all the claimants. So then they have to fight about their priorities. So that's something for another section. But that only happens if there's no letter of undertaking. Because there's a letter of undertaking, the vessel isn't going to get sold at auction, the vessel is going to sail on its way, and the claimants will be satisfied by virtue of the fact that the P&I Club has posted a letter of undertaking and agrees to pay all proven claims. So everybody got a clear picture of that. So let's cut.